views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
Welcome to today's verdict. I'm your host and trial attorney, David Lesch. We have a very big show today, 3 distinct topics. First, we have an attorney who's been on the show before, really to give you an update in terms of vaccinations and what you as an employer can require of your employee in terms of just even asking, have you been vaccinated? The second guest we have on has to do with a class action involving Bridgegate. I don't know if you remember Bridgegate. It has to do with the slowdown on the George Washington Bridge. And if you were on the particular bridge at that time, you may have a claim to certain damages with respect to loss of employment. And my final guest is an attorney from New York City Legal Services who really took on the New York City Housing Authority to make sure that the New York City Housing Authority reimburses tenants. You now will know exactly what you can do if you think the New York City Housing Authority has been doing that and charging you more than 30% of your income. So as you can see, we have much to get to. Today's verdict starts right now. All right, welcome back to today's verdict. I'm your host, David Lesch. We have a repeat guest, one of our favorites, and you have to be one of our favorites to be a repeat guest. Peter Rahbar, employment lawyer specialist, is here. Peter, welcome back to the show.
Thanks for having me, David. Great to be back.
Listen, last time you were here, let's give a little recap. COVID was in full swing. I'm not saying that it's not still around, but maybe not be as strong as it was. And we talked to you a little bit about vaccinations and employers forcing employees to get vaccinated, possibly firing employees because they're not vaccinated. And there was you gave us, some tips, but again, it's a developing area. Let's start from there. In terms of this new Delta variant, there are a lot of employers, myself included. Can I first even find out from my staff as to whether or not survey them just to find out who is not vaccinated?
Absolutely. That is permitted, and I would say highly encouraged because, as a first step, you should be, as an employer, you should be communicating frequently with your employees, not only to advise on the status of your plans and what you're thinking, but one of the questions you can ask is whether they're vaccinated or not, which, really could help planning. And some employers have used it to decide whether to have vaccine mandates or not. Some employers I've talked to were worried that they had large pockets of employees who were not vaccinated, were really stressing over what kind of policies they would need to have. I suggested that they survey their employees and ask them this question. And then they found out that they maybe had 1 or 2 employees who weren't vaccinated. And then, you can also have a conversation. Why aren't you vaccinated? Is it personal choice? Is it convenience? Is it health? And, for this one employer in particular, it was just personal choice. And when they were told that the company policies could be totally different for all their colleagues, they went and happily got vaccinated.
Do you send out, a 2-3 page survey? So at least you have it in writing, asking them the questions, are you vaccinated? When were you vaccinated? Do you have a vaccination card? Why won't you get vaccinated? Is it just so you have a record of it? Is that what you would recommend, really?
Absolutely. I think it's really important for employers to survey, and I think it's really important for employees to be honest in their responses. So an employer can absolutely ask you, have you been vaccinated? Can you provide proof of vaccination? They can ask to see the card or have it uploaded to, a secure site that they use. And if you're not vaccinated, there can be a discussion as to why. There are limits about what can be asked, but certainly a discussion can be had. And I encourage it.
Can you ask for proof? I mean, they tell you they're vaccinated. Can you actually say, I want to see the card? Can you ask for that?
Absolutely. you can ask for the card. You can ask for the card to be copied and be placed in a file. Some employers ask for things like the New York Excelsior Pass, which is a validated means of proving vaccination. So yeah, you should keep the card. And if your employer wants to see it, they can ask you to show it to them.
Now, I'm a private law firm, so that's what I will do. But what if I was a governmental agency? What if I was working for something I was working for some type of entity and I was being funded by federal or state? Make a difference or no?
Well, I mean, in New York, we have seen in the past week that there's been vaccine mandates and a push even by the government, whether it's in New York City or some of the other statewide cities to encourage employers to have these vaccine mandates. So some of the cities have mandates, and you should understand based on where you are what the legal situation is. But if you're in New York City, likely that's going to be a requirement. And now you have the government telling private employers to require vaccines, and so private employers are taking it very seriously.
So let's take it a step further now. So you've done your survey and you find out you have more than a handful who are not vaccinated. What can you do? The last time you were on, you said you kind of have to make an accommodation for them, put them in a place where they're not necessarily endangering the public. Can I fire somebody now for not being vaccinated? I'm a private employer.
Well, if there's no way to accommodate them, and if there's no accommodation that they're even seeking, let's say there are some cases where someone just for a political reason or a personal belief that has nothing to do with their religion or with their health doesn't want to get vaccinated, then certainly that person can be fired. What I'm finding is employers on the one hand want to do everything possible to open. But on the other hand, they really don't want to fire employees who aren't vaccinated. So it's really a means of last resort. I've found in some employers, if an employee doesn't want to get vaccinated, then perhaps and remote work is possible, then they'll remote work until they do that. Some employers are saying, if you come in and you're not vaccinated, you have to get masked and tested every day. But in some jobs, remote working is not possible, and testing every day is not possible. And so, those people are going to find themselves on the firing line. But I would say this overall, the script is really flipped.
Yeah,
the employers want to do everything possible to open.
Well, this is a law show. Let's talk lawsuits, because that's going to happen. Mm-hmm. I understand Mayor de Blasio is forcing testing as opposed to the firing in terms of the mandating vaccinations. What are your thoughts on that?
Well, I think that's one way to do it, and certainly lawsuits. There have been a couple. There was one even filed yesterday in Virginia. There was a notable one filed in Texas last month. And most of the claims are constitutional claims about right to bodily privacy, et cetera, and they're not winning. Lawsuits are getting dismissed.
I almost feel like there's going to be an ultimate question at some point before the United States Supreme Court, the right of the individual against the right of society. It's always that balance, and I just don't know where it's going to fall with respect to this particular vaccine. How far can you go to push those who are not vaccinated from not being a part of society? No restaurants, no movies, no gyms, you can't fly, you can't go on vacation. How far can you push, I guess? Do you think that's going to eventually be decided by, the big keys?
Well, I think there's certain elements in our society who are really determined to push it that far, frankly. And so likely there will be some form of case that does involve, I would say, a medical disability or something like that, a medical condition or disability or a religious belief where these mandates will be challenged, the public mandates will be challenged. But I would say, that's going to take time. Lawsuits take time, and we're dealing with this now.
I know we try and avoid lawsuits. And before I let you go, you're obviously doing some work for some firms to make sure that their policies are in compliance. Where can the viewers reach you if they need to?
Sure. You can reach me on my website, which is therebargroup.com, or my email, peter@therebargroup.com. It's pretty easy. I get back to you pretty quickly. And I'm working on these issues every day, writing policies, writing action plans, advising employees on how to deal with these issues as well. So it's pretty much all I talk about.
We love, well, that's good, because it's a hot topic and we love having you on. We're expecting you to come back fairly soon. In the meantime, have a great rest of the week.
Thanks. You too.
All right. Stay with us. Today's verdict has so much more right after this. We're back at today's verdict. We have with us today Luis Henriquez from Legal Services NYC. Luis, thanks for being here today.
Thanks so much for the invitation.
I very much appreciate, and I think the viewers will very much appreciate, what you have done really to hold the New York City Housing Authority accountable. You can just, give a little bit of a brief synopsis of what made you get involved with this particular issue and what the issue is. Go ahead.
So, as you know, the eviction moratorium, preventing mass eviction in this country is very much the conversation in this country right now. And it should be, it should always be. There's few things are more harmful than a family losing the roof over their head. And the way that our lawsuit is related to that conversation is that well before the pandemic, there was a pattern that we were seeing with our clients across the city in legal services, NYCHA clients, where they experienced a loss of income, requested the housing authority to have that their rent reduced on account of that loss of income, and the housing authority ignored their request, delayed their request, kept charging them the old rent, which was overestimated, and on top of that, sued them in housing court for non-payment of rent for rent arrears that, at least in part, were based on overcharges. And what's at play here is federal law, right? For half a century in this country, it has been federal law that public housing tenants cannot be charged more than 30% of income as rent. That is the law. NYCHA was systematically not following that law. We knew that ourselves because it was our experience from our individual client caseload. And so we were able to identify 12 clients from all of the 5 boroughs that we were already representing individually in non-payment cases in housing court. And they agreed to step up, put their story out there, sign up to be plaintiffs in this federal lawsuit to force NYCHA to change so that NYCHA ultimately follows the law, because this is what this is about here.
Well, NYCHA's been under a lot of political pressure to fix up their buildings and to do the right thing. And certainly if they're overcharging, their tenants, or not reducing the rent based on their own income, that's not so good. That's certainly not so good politically. But what you're telling the viewers is it's 30% of your income, right? Isn't that really the most they can charge in terms of rent?
Correct. Public housing is not the only type of housing that has what we can call the 30% rule, right? Section 8 has that rule, Mitchell-Lama has that rule, etc. But our case relates to public housing, which is Section 9, and our lawsuit is against the New York City Housing Authority. Every housing authority in the country, in every state, must not charge more than 30%. That's really the definition of what affordable housing is.
Now, there was a settlement here, all right? Am I correct? Mm-hmm. So that's the congratulations part. Obviously, you backed them off the plate and you got some money. Why don't you tell the viewers what you did for all the tenants in the NYCHA situation?
Yeah, so again, putting our clients here front and center. We were already representing them individually, but they agreed to put their story out there to be plaintiffs in this lawsuit. They wanted relief for themselves. They all got retro credits back. They all got damages for what they went through. But in particular, they agreed to be in this lawsuit to push NYCHA NYCHA needed to change its systems, right? What they were doing in the fact that tenants lost an income for the reasons that we know, right? They lost the job, They got cut back in their hours. Family member left the home that was making money, right? It was their federal right to go to the management office in their development and say, hey, I lost my income, get me that rent reduced. And to the extent that NYCHA did not do that for months, in some occasions, years. And on top of that, and this is the insult to injury, sued them in housing court for rents that were clearly an overcharge, put them at risk of eviction. That is what we really wanted to tackle in this lawsuit. And thankfully, we're very excited because we reached the settlement with the New York City Housing Authority that what it does essentially, it sets a new kind of like panoply of rules to make NYCHA actually do things the right way, that is follow federal law.
Well, that leads me to the next question. I mean, you were successful and that's wonderful, but there are a lot of people in the NYCHA system who have no idea what the rules are. They don't know what the rules are going to be changed to be. How do you get that out there so they know that they can either apply to get maybe some monies back, or they can figure out a way so that this will never happen to them and they're not overpaying for by the way, I'm not ashamed to say this. I'm going to tell you truthfully, I am not happy with the condition of the apartments and the buildings in NYCHA. They need to be completely renovated. My clients have been injured in all different types of ways, so I'm not saying. So, but what could you do to get the word out to these tenants?
So let me say what is the law right now and what the system will be when this settlement kicks in. First thing is that NYCHA has 6 months to make any operational changes it needs to make so that the new rules of the settlement are complied with. And so the new rules of the settlement, and I'll talk about them, actually kicking in January 2022, right? So that's thing one. But right now, again, has been the law in this country for half a century. Public housing tenants, as you know, their income is reviewed annually, right? That's called the annual recertification. However, if at any point in the middle of the year, you experience an income loss, you have a right to go to your management office, document that income loss, right? And management office must reduce your rent on a timely manner. That's the law before this lawsuit. So the first thing is that NYCHA tenants should know is that if you lost your job, if your hours got cut back, right? If a family member left your home, right now you can go to your project development office and request that your rent be reduced, right? However, like I said, NYCHA was systematically not doing that. So what is this settlement going to bring? Let me say three things. One problem here is that there was a huge lack of process in the way that all 325 projects handled this request, right? Some did it orally, some had a paper trail, there were no deadlines at play, there was lack of staffing, lack of training, all these things. So that's thing one that this settlement really does, right? NYCHA now has to resolve this interim, what's called interim recertification request to have your rent reduced in the middle of the year, within 60 days from the time that the tenant submits all documentation. That did not exist before, that 60-day deadline. It will be a rule now come January 2022. Thing two is, yes.
Go, keep going.
Yeah, let me just reset three things. Thing two is that NYCHA now, these processes now need to be fully documented, right? There needs to be a paper trail for everything, dated receipts, deadlines, the whole thing. The settlement goes into deep detail about exactly what that process will be, right? And then thing three, and this is key, so long as a tenant requests that the rent be reduced via an interim recertification or a rent grievance, NYCHA has to solve those requests first before suing tenants in housing court or before trying to terminate tenants, the tenancy of tenants by way of what's called a chronic rent delinquency termination proceeding. So NYCHA cannot jump the gun anymore, right? First, correct the rent, reduce the rent, and then if there are lawful arrears remaining, then you can go ahead and sue tenants.
Do the judges know about this? I mean, does the court system understand what's going on? I mean, I now know, but do the judges in housing court? Hopefully they do.
And this goes to whether you have a lawyer or not in housing court, right? If you don't have a lawyer and you're under the gun, you can be evicted. Chances are that you're going to agree to a settlement in housing court to pay money that you actually do not owe. That's exactly what we were seeing, right? If you have a lawyer, then yes, lawyers in our organization, sometimes it was their job to raise those claims, to get the housing court case stayed, so that the case can return to the agency, so that the correct rent can be calculated, that whole thing, right?
All right, well, Luis, unfortunately, we're out of time. You did great work, by the way. Very, very happy, very proud. I'm sure our viewers are very proud, and hopefully they're watching and they'll know what to do from here on in. And I'm hoping you come back fairly soon.
Thank you so much. And to your viewers who have any issues with rent overcharge, our number 917-661-4500. That is our citywide hotline. Please call.
Perfect. All right, stay with us. Today's verdict.
Thank you so much.
You got it. Resumes right after this. Okay, welcome back to today's verdict. I'm your host. We have Michael Epstein with us. This is a very interesting topic, a class action involving Bridgegate way back when. Michael, welcome to the show.
Thank you for having me. And I guess this case involves a bridge that separates the two of us.
Exactly, the GW. Let's give the viewers a little background. It's been a little while since we had this issue with the slowdown. Why don't we refresh the memory for the viewers?
Sure. So we have filed on behalf of what's called a putative class action, a putative class, a case for all drivers who were similarly situated on the days in question where the access lanes to the George Washington Bridge from Fort Lee were taken from 3 to 1, thereby creating extreme traffic delays.
Okay, and this was, by the way, a purposeful act. Am I correct? This was not a negligent act. This was done purposely by politicians.
So our allegation is that it was purposeful by, in particular, 2 high executives at the Port Authority of New York and New Jersey. That's the allegations. They take some issue with that, but I think we all know that it was intentional.
I think the general consensus seems to be it's a little bit of a payback for not supporting the governor and the governor's reelection bid. And I think there's been a lot of press about it, but that leads us to talking about this particular lawsuit and class actions, which really have to be certified. What made you decide that this was a case you wanted to take on?
Well, we geographically, we're close to that area. We thought from the beginning that the driver's constitutional rights were violated. The right to intrastate travel is a constitutional right in our view. And we thought that this intentional act by Port Authority executives who were appointed by Governor Christie had a major impact over a 4 to 5 day period on all of these drivers. And we thought this was a case that they deserved compensation for their losses over those days.
You know, Michael, you had thousands and thousands of drivers over that bridge on that day. None of them got to work on time, and most lost money, I'm sure. But that's a lot harder to prove in terms of each particular plaintiff than, let's say, Verizon, who's overcharging you for your cell phone usage and there's a class action, or something else when you know exactly what the damage is. I paid extra for the cell phone usage for my monthly fee of $200 a month, and now I should get back X amount of dollars. How do you go about quantifying the damages to all those drivers on the GW Bridge on that day?
That's a really good question. Actually, a great question, and it's a key question in the case. So for a class action, you have to show that the issues in the case are similar, that there's commonality, there's typicality. Those are the buzzwords, if you will. And so what we did, because we don't think you can individualize this, and no one's going to bring an individual case. It's too small of a case. It'll never get litigated. The only way to handle this case, in our view, and it's a pending case, so some things I can't say, but it's a class action. So what we did, and this is public knowledge, is we hired a transportation economist from Princeton University, who has a lot of awards and is world renowned, to create a model of damages for each driver who was delayed as a result of this intentional conduct.
How are you getting the word out to the drivers? You know, I assume if you were on the GW Bridge that day and you spent 3 hours sitting in traffic that wasn't moving, and you realized, oh my God, I was one of those drivers on Bridgegate Day. How do you get the word out to them? Because that's what you really have to do.
Right now, where we are is at the class certification stage. The motion has been filed. We will be getting a hearing date probably in the fall, and then we'll wait for a decision. If and when the class is certified, then we actually have to do factual discovery, which hasn't happened yet. But once the class is certified, the notice provision, there will be a notice provision that has to be mailed to all the class members. And one of the ways to do it is the Port Authority knows the people who went through that toll, that day because they have access to Easy Pass and other information to be able to do mailings, or if we settle the case, just give a debit directly to the Easy Pass accounts.
All right, so let's talk money here. I mean, what kind of money are we talking about? The whole general, where do you see this in terms of the amount of damages? What can this lead to? How big's the pot?
All right, so the pot, according to the economist from Princeton University, and the large piece of the damage is lost time. So as you know, as a personal injury attorney, a lot of times we value a loss in terms of hours or time. So here, one of the questions that was asked me, well, what's the damages? The damages is if you lost 3 hours sitting in traffic that day that you shouldn't have been sitting in, you can't get it back. We're all here for a finite amount of hours, no matter what it is, from 0 to death. And if you take away some of my hours, I can't get them back, and that's a compensable loss. So that's the bulk of the damages. There's 2 other pots. One is lost gas and fuel. Another one is we are seeking the tolls that were paid because the people didn't get the benefit of the bargain of using the tolls. All that combined is approximately $5 million.
Wow, that's a lot.
Yes.
And you know what, some other people may think, well, individually, what are you going to get? A couple $100 each, but it sends a message. And I think that many times that's the purpose of these class actions. It's not so much putting the small amount of money into the people's pockets. I mean, they move on with their lives. It's also sending a message to these companies that they can't get away with this, or to politicians or anyone else who's wronged the public in such a way and doesn't think they're going to have any repercussions. Would you agree?
No, I think that's really well said. I do agree with what you're saying. And the thing is that one person who maybe they're going to get $7,500, they're not going to bring a case for that because they're not going to get a lawyer. So you can't do it unless it's brought together in a collaborative way, and you can get to the 5 million for everybody. And you break it down amongst the thousands of drivers, it is X amount, right? So we hired this Princeton economist who said that there's an average hourly rate that should apply to these drivers that is reasonable, and then the amount of time that was lost. So that's really how we did it, or he did it, and he has an economic model that you need for a class action.
Well, listen, Michael, we don't have too much time, but I want to ask you really one last question. And this is really more of a political question. What transpired from this entire thing in terms of the political fallout? Did it really make a difference? Is this going to continue to make a difference? Your lawsuit, do you think it still can impact politics in New Jersey? Or are we done with that part of it?
I think we never brought it for political. I have never said whether I'm a Democrat, Republican, Independent, whether I like Christie or didn't like Christie, if I like the mayor from Fort Lee or don't like the mayor, or I supported him, I don't live in that town. We never looked at it as a political case. We looked at it as these drivers had their constitutional rights infringed and they should be compensated by the wrongdoers. That's really what we looked at it as. Given the time lapse, is if there's a repercussion from the case as it relates to politics, it's been a long time. So I really can't answer. I don't know.
All right. We have so much more in today's verdict coming back right after this. All right, that's all the time we have for today. I'd like to thank my 3 guests for joining us, and of course, you, the viewers, for watching. If you have an issue that you would like to see on a future edition of today's verdict, please feel free to email me at davidlesch@bronxnet.org. Until the next time, always remember, know your issues, reach a verdict. I'll see you in 2 weeks.